fellow South Africans, I'm addressing you this evening.
All your years of paying tax, you helped us overcome our darkest hour. You, along with every other loyal taxpayer, helped build this nation. Thank you for every life you saved and for every risk you braved, for giving our future generation a healthy start. When you saw many of our vulnerable communities, you provided for them. When you saw our healthcare workers on the front lines battling COVID, you rose to the occasion and gave them the tools to save lives. Without your tax compliance, we wouldn't be able to fight a good fight. Thank you for contributing to the important services our vulnerable communities rely on every day. To all taxpayers and traders, continue to pay your tax because it matters to millions of South Africans who depend on it. Your tax matters.
Ladies and gentlemen, a very warm welcome to you from us, the South African Revenue Services. We thank you so much for joining us tonight, and we promise you that you will get all the information that you're looking for. We'd like to welcome as well our valued stakeholders, our senior leadership of the South African Revenue Services, of which without them and without their innovation and progressive thinking, we would not have this webinar today. So tonight we have a very exciting and informative session lined up for you. We hope that you will get all the information that you are looking for. My name is Nomonde Wagwamhlongo, and I'm in charge of the King Shaka International Airport. So without further ado, I would like to welcome Mrs. Penny Bologo so that she may be able to welcome you fully. But before we get to that, let us ensure that we highlight issues of just the rules of the House. Firstly, if you have any issues, any queries that you would like to raise with us, we have a chat box on the side there, so you can just query, give your comments, give your suggestions as we are carrying on with this webinar. But secondly, we also have an email address of tariffquestions@sars.gov.za, and you can just write in there and ask for advice. We will ensure that our subject matter specialists are in tour and they will be able to give you the advice that you need. Mrs. Penny Bologo is an executive in accreditation and licensing unit at SARS, having begun her career in a junior role as a customs inspector at Durban International Airport. She has acquired extensive customs and excise experience over her years of being employed at the South African Revenue Services. Penny has a Master of Business Leadership MBL from the University of South Africa. She also graduated at the Graduate School of Business Leadership in SBL, Master of International Customs Law, an administration from University of Canberra, Australia, and a Bachelor of Arts in Social Sciences from the University of Zululand. She has represented SARS at various international forums and on trade facilitation with the WCO, the SADC, the IORA, and Afritech, the global AEO conferences in Mexico and Uganda. Together with, she has served as chair of the SACO AEO working group. In addition, Penny has successfully implemented the AEO program in May 2017. Ladies and gentlemen, without further ado, a very warm welcome to our executive, Mrs. Penny Bologo.
Thank you so much, Nomonde, and good afternoon, ladies and gentlemen. There is a very nice and warm welcome from the program director. Ladies and gentlemen, as indicated by the program director, my name is Penny Bologo. I'm the executive for accreditation in SARS, and it is my pleasure to be in this webinar this afternoon to share with you the insights on some of the valuable SARS-related programs. I hope you're going to enjoy this webinar and you're going to stay with us throughout the webinar. It's not going to take your whole evening. It's only an hour with us. Today, you will be hearing a lot from our colleagues pertaining to customs and excise tariff determination, the World Customs Organization harmonized system, and some of you may have even be wondering, what could that be? Who qualifies to apply for a tariff determination? Perhaps how does a trader even go about making an application for a tariff determination in the region or in head office? I thought it's important to share with you today that the World Customs Organization is a custodian of this HS, which is a harmonized system. that's responsible for tariff matters. And SARS is as a contracting party to the HS conversion, and SARS actively participate in the following. SARS participate in the HS committee, and this committee is responsible for global determination guidelines. It also sits at least twice a year in Brussels. This committee, amongst others, it is responsible for uniform interpretation and application to settle classification questions and disputes at a global level through inputs made by the experts from across the world. So that's how important this particular forum is. The HS committee is also responsible for securing speedy and uniform implementation of classification decisions. Please note that SARS also supports the process by the WCO-HS committee to publish instruments adopted by the very same committee after the Council's approval. This is done as part of the stakeholder education and trade empowerment, which is key for traders. It is also fitting that I touch on the WCO Green Customs Initiative. And this initiative is the initiative that has been presented and shared by the WCO itself. The WCO organized the Green Customs Global Conference on the 27th and the 28th of June 2022. This was done to raise the awareness of customs' role in protecting the environment and hear the expectations from customs from a range of stakeholders. In his opening remarks, the WCO Secretary General, Dr. Cunio Mikoria, explained the green customs as one of the focus areas in his strategic plan. He also made mention of the importance of hearing stakeholders' views to well-position customs' role in addressing climate change and related environment issues. Colleagues, this is also in line with the SARS strategic objective number 8 in terms of working with and through stakeholders together with our innovative drive to align the global trends. While there was a strong demand expressed for more granular code of environment, goods of identifying its impact, and it is also agreed on the implementation of aspects from HS and HS view cycle. Ladies and gentlemen, in closing, as an AEO ambassador, I would like to take an advantage of this opportunity by being in this platform, by encouraging each one of you to join the SARS AEO program where your tariff determination application gets prioritized. Let me not unpack that because I've got a very brilliant colleagues that are going to share with you what does that mean. Let me pause here and to allow my colleagues then to tell you how quick or how long does it take for a tariff determination application to be finalized. As soon as you hear that, you'll know why I was inviting you to the AEO program. You will then call me and ask, how do you join an AEO program? And this is a program where you get a VIP treatment, which is a WCO program as well. So ladies and gentlemen, with that being said, I hope that you're going to enjoy the rest of the day today. And you're going to find this webinar very meaningful and very fruitful to what you would like to hear. I hope it's going to be as beneficial as we had planned it to be. I thank you, and back to you, Program Director.
Thank you very much, Mrs. Boloko. It's spoken in a very true and succinct state to prove that this is really an executive leader that is speaking to us. Ladies and gentlemen, I'm not going to waste any more of your time. I'm going to lead you directly to the two beautiful ladies that are going to be addressing you tonight and that are going to be giving you more information regarding to what we have gathered for tonight. Now, it is not my plan, and I did not formulate this program, so it is not me that has put together only ladies in this afternoon's webinar. But let me take you through Mrs. Lydia Madibeng as well as Silwane Molebatsi, who will be taking you through the presentations. Let's read the profiles and find out if they are really worthy of presenting today. I feel that you will nod your heads at the end of this and understand why we've asked them to present tonight. Lydia Madibeng is a senior specialist in international trade responsible for tariff classifications and incidental matters. She started her career at a junior level as a team support member in the anti-smuggling unit at OR Tambo International Airport. During her tenure, which opens 20 years back, she has gained extensive technical expertise in various managerial roles within customs and excise, legal and policy, and insight, and has a lot of insight in different ports of entry. Ladies and gentlemen, we are in the presence of greatness indeed. Lydia is a South African representative at the biannual World Customs Organization Harmonized System Committee and Harmonized System Review Subcommittee meetings. She serves as a representative at capacity as a contact person for South Africa to the EU and WCO Harmonized System Program for Africa. She was instrumental in the formation of the SACU Technical Working Group and for the Harmonized System, Origin, and as well as Valuation. She represented South Africa as chairperson for the SACU Technical Working Group on Harmonized System and Origin Valuation for the 2020-2021 financial year. She is currently serving as a champion for the SACU Technical Working Group on Harmonized Systems, Origin, and Valuation from July 2021. She holds a Juris degree from Vista University, a graduate diploma in Customs Administration, and a Master's of Customs Administration from Charles Sturt University in Australia. Let us go through and read the profile for our second presenter, Ms. Silwane Molebati. She joined SARS in 2015. She is currently a manager in the Tariff Determinations Unit and leads a team of experts in tariff determination. Molebati has over 15 years experience in international trade and customs tariff determination and has worked in various positions at the International Administration Commission of South Africa, which is ITAC and SARS. She has participated in trade and customs tariff-related matters at the South African Customs Union, which is SACU, as an advisor on the establishment of the SACU Tariff Board, and at the East and Southern Africa, which is the WCO ESA region, as a manager in the office of the WCO Vice Chair ESA region as well. It was in this role that she was awarded the WCO ESA National Contact Person of the Year Award in 2017-2018 during the 23rd WCO ESA Governing Council hosted in Kigali, Rwanda. She is the current chair of the SACU Region's Working Group on Harmonized System Matters. Ladies and gentlemen, as I advised, we are in the presence of greatness. And I'm going to hand over to these two beautiful ladies to take us through the rest of the presentation. Over to you, ladies. Let's just ensure that the presentations are set up properly. Ladies and gentlemen, while we are still sorting ourselves out, let me just remind you that you can continue to give us your questions at tariffquestions@sars.gov.za, but also in the chat box on the side. I promise you that we have our willing and very able colleagues that will be able to give you the responses that you need currently. And also, may I just advise you that at the end of the session, we invite you to please ensure that you fill in the survey that the system is going to prompt you to fill in. That will be very, very appreciated, because we'd like to also ensure that we improve on our services. We want to ensure that we do our best in the next couple of presentations that we are going to have. And as you all know, ladies and gentlemen, this is not our last session together. We still have many, many more webinars to come. And we invite you to please take care of that. And please join us as the South African Revenue Services in ensuring that you get yourself informed, so that we may ensure that we learn together, we grow together as an organization. Over to you, ladies.
Good afternoon, ladies and gentlemen. My name is Lydia Madileng. I am the Senior Specialist at Tariff. I'll be giving a presentation today on tariff classification. The presentation will be in two parts. One part is for tariff classification and one part is for tariff determination application process. The purpose of this presentation, ladies and gentlemen, is to provide clarity on tariff determination procedures, as well as to make the law accessible to the public. Where any statement made by us during the presentation, where we will be referring to legal provisions and any inconsistency is identified, ladies and gentlemen, the provisions of the specific legislation that we seek to clarify shall prevail. Ladies and gentlemen, before I start with the subject matter tariff classification, may I take this opportunity to refer you to the SARS Vision 2024. We as an organization, we endeavor to build a smart, modern SARS that is trusted and admired by government, the public, as well as our international peers. Ladies and gentlemen, may I also refer you to the 5 of the 9 strategic goals of SARS, which include, amongst others, it is our intent to make it easy and simple to comply. We are working on modernizing our system to provide seamless online digital services. We are using data for insights, for risk, and also to improve our outcomes. We are providing platforms for awareness, clarity, and certainty. And the mandate or the strategic intent at the end of the day is to make it hard for our traders not to comply. The presentation will touch on national legislation and international legislation, with emphasis on the revised Kyoto Convention and the harmonized system. We will also touch on non-compliance, tariff determination process, stage consignment, and last but not least, dispute resolution. Ladies and gentlemen, there you have it, a list of our legislation that we normally use in the performance of our daily work, with the Customs and Excise Act being the primary legislation. As I indicated, that we will touch on international legislation insofar as it relates to the subject of today. The revised Kyoto Convention, one may ask a question, what is it? It is an international convention on the simplification and harmonization of customs procedures. This is an international agreement that provides for principles to which contracting parties commit to. It is not binding on customs administration, but it is used as guidelines and considering the harmonized processes and procedures and practices globally that customs administrations have adopted. It is a clear sign that the revised Kyoto Convention is widely used and or adopted. International law on penalties, as I have said, the revised Kyoto Convention set out the principles to which the contracting parties commit. If one can look at the provisions of the primary legislation, which is the Customs and Excise Act, it is reflective of the principles of the revised Kyoto Convention. If one may look at, for example, Annex H of the revised Kyoto Convention, it provides that national legislation should provide for customs offenses. The revised Kyoto Convention provides for different standards to which the contracting parties must make sure that they implement within a certain period as undertaken by themselves. Therefore, or shortly, ladies and gentlemen, let me take this opportunity to indicate that our primary legislation on classification and on customs procedures and practices in general is reflective of the provisions and procedures and practices of the revised Kyoto Convention. Okay, the subject of today, tariff classification. One may ask the question, what is tariff classification? Tariff classification is a process whereby one will endeavor to determine a code for goods with the aim of recording the accurate information in relation to those goods. Why do we need to classify goods? There are obligations that are set out or laid out in the provisions of the Customs and Excise Act, specifically Schedule 1, Part 1 of the Act, and other schedules where there are provisions for additional customs duties. We therefore classify to determine customs duties. We classify in an endeavor to make sure that we harmonize the codes that we are using as a country, and also to reach interpretation insofar as the interpretation principles are concerned. We classify to give effect to trade agreements. If one may look at the Schedule 1, Part 1, let me take you to the next slide. If you look at this slide, there are tariff headings on the left column, and there are descriptions, and on the right, there are different trade agreements which are international agreements. Like I said, the Customs and Excise Act is enacted in line with the revised Kyoto Convention, and it incorporates in it the provisions of the harmonized system in section 47.8 thereof. On the stages of classification, how does one go about classification? Ladies and gentlemen, classification is a three-stage process. First, one needs to ascertain the meaning of the words used in the headings and relative section, as well as chapter notes, which may be relevant to the classification of the goods concerned. Second, one considers the nature and characteristics of the goods. Third, one will have to select, after ascertaining the meaning of the words, my apologies, after considering the nature and character of the goods. And a third, one will have to select the heading which is more appropriate to the goods. And in so doing, one will have to determine the meaning, and if the meaning of the words in the tariff heading text or the section notes or the chapter notes, one will have to refer to the explanatory notes, which do not, like the chapter notes and section notes and heading notes, which do not have a legal, which are not legally binding, but are there for clarity, hence the name explanatory. They are there for clarity purposes or to aid in interpreting the scope of the heading or the section. But in doing so, one will not use the explanatory notes to alter or to amend the scope that are provided by the set headings or chapter notes or the section notes. The harmonized system. This is an international agreement or convention, ladies and gentlemen, and one may ask the question, what is it? The harmonized system is a multi-purpose legal tool that provides for adequate communication platforms, the HS meetings, for example, as our Penny Bologo have indicated in her speech. The HS includes availability of national tariffs. From the example of that page of Schedule 1, Part 1 that was showing different international agreements and also tariff subheadings, those headings were taken from the product list or the nomenclature of the harmonized system. As I indicated, ladies and gentlemen, Section 47(8) of the Customs and Excise Act empowers the Commissioner. It empowers SARS to incorporate the provisions of the HS in the Customs and Excise Act. Therefore, in the performance of our work as tariff specialists, while classifying goods, we consider the provisions, the legal provisions of the harmonized system. The harmonized system further provides for classification principles. And lastly, but not least, ladies and gentlemen, it is a source of many trade policies, as evidence evidence on the Schedule 1, Part 1 page, which I showed. Yes, here on this page, there are trade agreements, and the tariff headings in Schedule 1, Part 1, up to 6-digit level, are identical to all customs administrations internationally. And at 8-digit level, customs administration regions, they would come up with the 8-digit tariff headings. Some countries will come up with the 8-digit and 10-digit. But for our purpose as SACU, as a region, we make tariff subheadings up to 8-digit level. One of the principles of the HS, ladies and gentlemen, is the general rules of interpretation. There are 6 general rules of interpretation in the HS, from General Rule 1 up to General Rule 6. They are the main tool for the daily application of the HS. I will take you through the general rule of interpretation in the next slides. General Rule 1, it provides that titles of section, chapters, and subchapters are provided for ease of reference only. For legal purposes, the terms of heading and any relative or chapter considered. And there are examples of sections and chapters on the slide. General Rule 2A. This rule, we apply it when we are faced with classifying incomplete or unfinished articles. And how do we go about? What does the rule say? What is the guidance that the rule gives? The rule is saying, if you are faced with classifying an incomplete or unfinished product, you will have to determine whether that unfinished or incomplete product is having the essential character of a complete or finished article. And an example here is an incomplete bicycle. How we approach it, for example, if we have to classify unassembled parts of a bicycle, we consider the first, we must ensure that the frame and fork form part of the parts that are presented, and at least a minimum of the major parts that are listed with the ticks, the four major parts. If 2 are present, then we classify those unassembled incomplete parts of a bicycle as a complete bicycle. GRI 2B, this is a rule that provides for mixtures of composite articles. If you are faced, or if we are to classify a consignment that is made up of different material, the material that predominates, we will classify the products as the goods to be consisting of that material. An example here, we have peas and with sugar, peas at 51% and sugar at 41%. Therefore, this will be classified as sweetened peas. Okay, General Rule 3. There are 3 types of this rule. First, we have GRA, which provides for where there is a heading that is general and a heading that is more specific. One will have to select the heading that is more specific. General Rule 3B, if a product is a composite product, meaning it is made up of different components, one will have to determine the product as if it is made of the material that gives its one will have to determine it as if it consists of the component that gives its essential character. The essential character of General Rule 3B and General 2 is different in that goods of GRI 3B are ready for use, even if unassembled. But goods of GRI 2B, the essential character, since it is incomplete products, it is not ready for use. General 3C, if one is unable to determine goods in terms of 3A and 3B, then the heading that occurs last in numerical order must be preferred. GRI 4, this is for goods that are newly on the market and that we haven't determined before. We look into similar goods or the goods to which the presented goods are most akin to, and we classify those goods as the goods that we have already classified. GRI 5, it provides for containers that are presented with goods. They are to be classified with those goods, not like separate. GRI 6 provides for classification of headings at subheading level, and it provides that subheading at the same level are comparable. Ladies and gentlemen, let me give an example of the tariff headings. At the international level, we have 4-digit tariff heading and also 5-digit tariff heading and 6-digit. 8-digit is for national. Yes, the last three will be for SACU purposes, but international, the first 6 are similar to all countries. Other classification principles, we have sections, there are chapters, tariff headings, tariff subheadings, and all these together with the explanatory notes, they form legal notes. Please bear in mind that the explanatory notes do not have a legal basis. They are used to clarify the scope of the extent of the scope of the sections or the legal basis provided by the sections, the chapters, and the tariff subheading, and also the tariff headings and subheading notes. Arrangement of sections and chapters is based mostly on material content of products. It can also be based on usages. It can be based on stage of processing. As I've said, ladies and gentlemen, sections, chapters, they form the legal basis. Ladies and gentlemen, there are always consequences if there is non-compliance. Failure to declare the correct tariff heading constitute an offense under the Customs and Excise Act. And if I may take you back, the basis is in the revised Kyoto Convention. The penalty can be in the form of monetary. It can be a monetary penalty, but the trader will have to give the commissioner an indication whether they elect to be dealt with administratively or not. If the trader elect not to be dealt with administratively, the commissioner will have an option to institute legal proceedings, or alternatively, the commissioner can initiate steps to cancel the registration of a client or license. With that, ladies and gentlemen, this brings us to the end of my presentation, and please afford me this opportunity to hand over to my colleague, Selwane Molebadzi. Selwane, the floor is yours. Thank you, ladies and gentlemen.
Good evening, ladies and gentlemen. My name is Selwane Molebadzi. Allow me to appreciate the program director and the speakers that came before me in laying the foundation on this very important topic for tonight. Tariff is one of the important pillars of customs, alongside rules of origin, and valuation. Hence the importance of this webinar. My colleague has went at length to elaborate on the HS system and the tools used thereof to aid you in the classification process. Maybe the question in your heads right now is, what then happens in an event where I have went through all these principles and methods, but I'm still unable to classify? Well, my duty tonight is to take you through a simple process or to clarify the process for an application for a tariff determination, and to also inform you that, yes, SARS has made provision for you to apply because we really want to assist you comply. But before I do that, let me take you through the process, but let me inform you that for any person intending to import or export, they must be registered with SARS in terms of the Act. Registration can be done via e-filing or at any of our customs branches through the regions. The application for a tariff determination can be submitted by the trader seeking clarity, or it can be a departmental submission submitted by one of our officers due to the following processes.
Silwane, perhaps while you're still getting things together, let me just remind the ladies and gentlemen about our platforms. We are still waiting for you, ladies and gentlemen, to upload your questions in the chat box, as well as our email address, which is tariffquestions@sars.gov.za. Over to you, Silwane.
Thank you, Program Director. Ladies and gentlemen, as I have mentioned before, a tariff determination process can emanate from any of the following customs procedures. Let's say, for instance, you have went through the harmonized system, you have gained confidence in classifying your own products, and you have started the business of importing. During an importation process, your goods go through customs declaration, and the customs officer picks up that the goods as declared during this process do not match the documentation. They can refer you for a tariff determination. Or for instance, during a declaration process, your goods are routed through for inspection. During inspection, one of our officers discovers that the goods as presented do not qualify or are not classified correctly. In this instance as well, they can advise you to apply for a tariff determination. At the beginning of the webinar, our speaker referred to an AEO program. This is a program where you benefit from getting a VIP treatment because you are a compliant trader with SARS. In this instance, SARS will allow your goods to go through, provided that your documentation is in order. Then at the end of the process, maybe at a later stage, our auditors then goes through a process of an audit. During this process that we call a post-clearance audit, our officers can then discover that the products as they see them during the audit process were not correctly classified during the declarations process, although we have allowed you to go through. In this process, you can then be also advised to apply for a tariff determination. Another process that can bring a rise to a tariff determination process is where we work very closely with some of our internal colleagues in the process of tariff classification. For instance, we have colleagues in the tariff determination amendment section These are colleagues who work very closely with the International Trade Administration Commission of South Africa, which is the body responsible for amending duties paid when you import. An importer may apply for a change in duty. Before that can be done, a classification has to be clarified. We also work very closely with other government departments who require a tariff clarification. Ladies and gentlemen, it is very important for me to note, for you to know that a declaration released or entered or an opinion given verbally is not deemed to be a tariff determination. Goods are classified as presented during the declaration process. Once a tariff determination has been issued, the commissioner may amend or withdraw it to make a new determination for reasons stipulated in the Act. Any determination issued is deemed to be correct, subject to an internal dispute. Ladies and gentlemen, those are some of the important things that I wanted you to note before I take you through a process of a tariff determination. So for instance, let's say you have been trying to classify goods on your own, you have went through the HS system, but you realize that you are still unable to classify. Well, it is my pleasure to inform you that you can apply for an intended import determination. We can also have a situation where company X, Y, and Z has done its homework, they went through the harmonized systems and all the principles, and they have begun their process for importing their goods. During any of the processes that I have just explained above, the procedures to speak, then they are informed that they need to apply for a tariff determination. Now they have accepted the advice to apply for a tariff determination. It is important for our traders to familiarize themselves with the tariff determination external policy, which is available on our website. Once you have familiarized yourself with this policy, you will find in it the requirements and all the information that you need to submit in order for your application to be complete and be considered by our office. Now you have all the information that you need. You can then submit your application manually at any of our customs offices or at the head office in the case of an intended import. Once the customs officer receives your application, they will check this application to ensure that all the required information is included in your application. They can either refer it back to you for further information where they pick up that there's something that you have left out, or they can continue with the process for a tariff determination. The officer must capture the application in the TDN tariff determination system on a D831 form and issue you with a serial number. This is the number that you will use to track your application throughout the process. Once they have captured the application, they will then manually mail all the supporting documents to the head office. Once the supporting documents are received at the head office, your case will be allocated to one of our very knowledgeable specialists who will assess your application using the HS principle and tools, as my colleague has already explained, mainly the rules of interpretation. Once they are satisfied that they have verified and the classification is correct, ladies and gentlemen, I must also inform you that this is a very rigorous process that involves research and analysis, reference to other customs organizations, previous rulings, and so forth. It also goes through a number of checks whereby we have specialists up to a level of a senior specialist to ensure that the classification that we issue is correct. Once the classification is issued, the information is then captured in the D8314 routed back to the branch office. That is where the officer who captured the application then receives this outcome. They will communicate the outcome with you. And yes, that's how the process is undertaken. Ladies and gentlemen, we also do determination for alcoholic beverages. In terms of the Act, first-time importers and exporters, all manufacturers of alcoholic beverages require a tariff determination. The application must be submitted at any regional office or the head office for consideration. These applications must be accompanied by a signed certificate from the Department of Agriculture, Forestry, and Fisheries, confirming that the alcoholic beverage complies with the Liquor Product Act. In the submission, the application must include the product information, including the brand name, the manufacturing process, the ingredients and the proportions used, the alcoholic strength, and any other information as may be required by the Commissioner. Ladies and gentlemen, we also issue tariff determinations for staged consignment. For instance, maybe you might be asking yourself, what is a staged consignment? A staged consignment involves an importation of unassembled or disassembled machinery, mainly used for industrial purposes, to be imported in different stage consignment, but classified as one machinery product. You'll remember earlier on in my presentation, I did mention that products are classified as presented. So in the case of big machinery like industrial machines, it is not practical for shipping purposes because of the sizes of these machines for them to be imported in one consignment. Hence, the Commissioner has made available a provision in terms of the Act where he may allow importation of this machinery in stage consignment where the mass exceeds 500 tons or if the measurements for shipping purposes exceed 500 cubic meters. It is important to note, ladies and gentlemen, that the application must reach SARS prior to the importation of the first consignment, and it must comply with the requirements as set out in the stage consignment external policy, which is also available on our website. Ladies and gentlemen, goods in transit or bound through South Africa and any goods exported from South Africa may not be classified under stage consignment. Right, now we have went through the process of an application. You have managed to successfully get your products classified by our knowledgeable experts. You have received an official copy of your tariff determination. However, you are unhappy for some reason, because fair enough, you have went through the rules of classification. You were confident that the classification that you have provided during your import was correct. However, you are informed that through the determination document that your product must be classified otherwise. What do you do? Ladies and gentlemen, it is my pleasure to inform you that SARS has the internal dispute processes that you can explore in order to satisfy yourself that the processes that we have used are really fair and correct. If you are aggrieved by the decisions of the Commissioner, your recourse is to 1, you can appeal the decision within the 30 days from the date of receipt of the determination. 2, you can apply for an alternative dispute resolution within 30 days from the date of the appeal outcome. That is in instances where your application has went through the appeal process and you are still unhappy with the outcome of the appeals committee. Then you have the recourse through ADR. Ladies and gentlemen, lastly, SARS has provision for you to litigate our decisions through the courts. This can be done within 1 year from the date of either an appeal an ADR, or a tariff decision. What do I mean by that? It can happen that after we issue with the tariff determination, you realize that the deadlines for submissions for an appeal or ADR have passed, but you'd still like to pursue or challenge our decisions. This is where a litigation process comes in. So in other words, a litigation process can be used to either challenge an appeal, ADR, or any decision made by the commissioner in terms of a tariff. The submissions must be made at the office where the decision was issued. It is important to note, ladies and gentlemen, that no duties, levies, or taxes which are due and payable may be waived. However, these amounts may be suspended pending the outcome of the applicable appeals committee decision. The process of litigation. All right, now you have explored all the internal processes. You went through appeal, you went through ADR, or you have missed the deadlines for submission for an appeal. What do you do? Or you choose the litigation process. Then the Customs and Excise Act makes provision for you to litigate, as I've already indicated. Applicants exercising these rights are required to give the commissioner a notice in writing prior to instituting these legal proceedings. The notice must be given within a year from the date of receipt of either an IAA, ADR, or a tariff outcome to the address stipulated in the outcome. Ladies and gentlemen, most of you might be familiar with the recently published Service Charter by SARS. For those of you who do not have the Service Charter, it is available on our website. It is a document where SARS commits to finalizing your application within reasonable times. SARS will endeavor to finalize your applications within timelines as stipulated in the Service Charter, provided all required information is submitted. For a tariff determination process, it will take us 90 working days to finalize. It will take us 60 business days for an appeals process and 90 days for an ADR. A notice to litigate, which you would have submitted within a period of 12 months, will be finalized within 30 days, or there can be extension if agreed between the parties. Ladies and gentlemen, traders accredited under an AEO program enjoy the benefits of jumping the queue. The criteria for qualifying under this very awesome program are available on our website, and the link is also attached to the presentation. So I encourage you to go through the criterion, do your best to comply, and you will definitely jump the queue. It is also important for me, ladies and gentlemen, to mention that some of our tariff determination is a complex subject. Hence, you see the timelines as reflected in the Service Charter. Ladies and gentlemen, you are welcome to also go through our website. You will find other search engines that will assist you in the process of tariff classification. Remember to go digital. We've made it easier for you. You can register for e-filing and conduct your business with ease, or you can contact us through our query email at sars.gov.co. Lastly, ladies and gentlemen, let me thank you for allowing me this opportunity to share with you on our processes for tariff determination. I will now hand over back to the program director. I thank you.
Thank you so much, ladies, for doing such a sterling job this evening. I'm going to hand over now to Mr. Gumani Mugeri, who is our senior manager in our training session. Now, before I hand over to him, I know that he's still sorting himself out. It will not just be him, ladies and gentlemen, it will also be a panel of experts that will be looking at answering your questions. But let me highlight before we move on. Number one, ladies and gentlemen, thank you so much for the energy that I'm seeing. I see a lot of questions coming through in both the chat box as well as the email address. Thank you so much for being so interactive. And also, maybe to highlight on a lighter note, we've noted that we are having about 5 speakers tonight. And out of those 5, 3 of which have been women, and they have done an absolutely sterling job, from Penny to Lydia to Silwane. And let's not forget that the program director is also female. It goes to show how progressive our organization is. Just a side note, no pressure, Mr. Kumani. I'm going to hand over to you and your panel of experts. Thank you.
Thank you very much. We are joined in the panel of experts by Amy George from litigation, Rufuno Mngodi from alternative dispute resolution, Letitia Calvert from tariff amendment, Patricia Jones from process, as well as Lerato Chibinyane. I will allow Lerato to give us an outline on some of the considerations with regard to tax incentives and some important information pertaining to traders information sharing. Patricia will take over the panel discussion and run through the Q&A. Thank you very much. Lerato, you can take the floor. Lerato will be on audio. Unfortunately, you won't be on camera, but the floor is yours, Lerato.
Okay, good evening, ladies and gentlemen, and I hope that I am audible. So my role this evening is just to give you a high-level information about the incentives that we have for you as our traders, because we would like you to take advantage of them. So we have the different types of incentives that we feel you should know about. So just to give you an example, we've got the VAT refund that you can take advantage of, which is meant for tourists and foreigners at export when taking the goods out. We also have those that are meant for SA registered vendors, and they can make use of what is called the VAT Export Incentive Scheme. And some of the benefits that they may apply for is VAT at the 0 rate, where they can, where movable goods can be exported, provided that satisfactory proof of export can be furnished. Then we also have incentives for rebate users that are registered with SARS as well as ITAC. ITAC is the International Trade Administration Commission. So where applicable, you would have to register with ITAC as a rebate user. And what these entail is that there can be a suspension of customs duty on imported goods that are used in the manufacture or processing, finishing, equipping, or packing of goods, which is exclusively for export. So this will assist exporters in avoiding, the strain of laying out of cash outlay, which we know that is very much needed in their day-to-day business. As my other colleague indicated earlier, Penny Bologo, we have the AEO, which is the Accredited Economic Program. So this is a cheaper and easy way of moving goods through our borders. So there's numerous benefits. It ranges from reduced stops, inspections, reduced surety bonds. You get allocated a customs relationship manager. There's, in some instances, an opportunity for you to have inspections of your consignments done at your premises. So there are many. And we also have the deferment scheme. Through the deferment scheme, you are allowed to do some transactions on import whereby you don't have to lay out cash immediately to account for the duties and VAT with SARS. However, on a periodic basis, you can then come back and reconcile and, settle whatever it is that you had outstanding with SARS. So it's more like an account that you have with SARS that you can move goods through and pay at a later stage. Then we also have different types of trade agreements that South Africa signs up and is part of. There are many, but just to give an example, the SACU, which is the Southern African Customs Union, the European Union, as well as the AFCATA. And basically these trade agreements is to make room for reduced or free duty on those areas as agreed by the member parties. Now, the other thing that I wanted to touch on was just to remind you while I'm on this platform that we do have a website where we do try to reach out and inform our SMMEs, which is on our small business page. And to access this page, you would have to go to www.sars.gov.za, and then you go to the small business page. Once you are on that page, you will see there's different subheadings that you can access. You can access through the business and employers, through the tax practitioners, as well as through the customs and excise page. You would just have to look out for a subheading that says small business traders and travelers. That is where we update most of our information, which includes even the upcoming webinars that we'll be having. And just to end, I would like to also encourage you to look out for our upcoming webinar, which will be focusing on customs and excise incentives. So the incentives that I mentioned earlier on a high level, you can join in that webinar where you'll get full information on what the incentives are, as well as how to make use of them. Thank you very much. And over to Patricia Jones.
Thank you very much for that information. We've got quite a few questions tonight, so I think I'll first hand over to Lufuno because we've received a question and maybe he can provide a bit of clarity on that. And it is, what mistakes do people commonly make when they're handing in an appeal or an ADR, and how can we assist them to ensure that the submissions run smoothly? Lufuno?
Thank you, Patricia. Ladies and gentlemen, we all know that the ADR is a process which is guided by the Rule 77I of the Customs and Excise Act. Those rules guide the process from the beginning to the end. But the most common challenge that we are facing every single day is the quality of the submission of the ADR application. Ladies and gentlemen, you will find that the application itself does not have supporting document. I believe maybe they believe since the ADR application comes after the IAA process, they think maybe perhaps we do have a lot of document and we don't have. So the main challenge is that the quality itself is not accurate, and it also affects the turnaround time. You remember on the slide that was the information presented by Silwana, she clearly indicated that the ADR turnaround time, Patricia, is 90 days. So if we don't have a quality application together with the supporting document, prescribed form DA52, literature, all those information, if it's not there, it becomes a problem to meet the deadline. Thank you very much, Patricia.
Thank you so much for clarifying that, Lufuno. And also just to indicate that we do have the information on our webpage that it basically helps and assists you in the submission of your ADR processes. So thank you very much for the comprehensive response. The next question that we have, and I think that do we publish previous tariff determinations on the SARS website for reference? If she can just give us that response, thank you. Okay, I think Selewani is having a challenge with that. Maybe Letitia can assist us with that response.
Thank you, Patricia. To my knowledge, we are not publishing the tariff determinations on the SARS website as yet. But as Selewani is available, she can perhaps just confirm if that is the case. Thank you.
Thank you very much, Letitia, for that answer. Just to clarify as well, no, we do not. The tariff determinations are very specific to an individual when they do apply. We are looking at legislation further down the line where we would most probably make this available to all. Thank you so much, Letitia. The next question is, we're getting quite a few of this, is whether we're going to be making this presentation available on our website. So I'll answer that. Yes, we will be doing that. We will be publishing it on our website. And this session will also be available on our YouTube channel for viewing at a later stage. The next question that we have from Tukozani is, will there be any platform in the future whereby rulings by SARS Customs are made public? Something similar to the cross rulings. Lydia, if you are available, could you please respond to that question?
Good afternoon, ladies and gentlemen. Once again, Patricia, can you repeat the question?
Yes, sure. The question from Tokozani is, will there be any platform in the future whereby tariff rulings by SARS Customs are made public, similar to the cross rulings?
Yes, we are working on that. We are not publishing yet, but currently the tariff determinations that we issue are private to the companies to whom they are issued. That is in terms of Section 4 of the Customs and Excise Act. So we are working on legislation to have the rulings published in future. SARS is working on the legislation. Thank you.
Thank you, Lydia. Another question that we've got is from Zier, and he's asking, if you have 2 items in a gift set box, example, a watch and a pen, what tariff code do you use? Also, if both items have the same value, which tariff code do you classify these items? Lydia or Selawani, can you respond, please?
Thanks, Patricia, for the question. If a watch and a pen are presented together, those 2 items are not, they are not a set. They will be classified separately. Each will have its own tariff heading.
Thank you, Lydia, for that response. The next question that we've got is from Kane Woolmer, and I think this was responded to already, is what is the tariff determination turnaround time, and where does one track the status of an application? Lydia, back to you, sorry.
Thanks, Patricia. Actually, the tariff application turnaround time is 90 days, but we are trying the best that we can to improve our service. So we are trying our best to minimize it to 45 days. Thank you.
Thank you so much for that response. The next question is from Herman, asking if there's a possibility for us to submit the application via email. I think the email address was provided, and we'll put that in the chat box as well for everybody's reference. And also, Selawani, can you expand on that? Thank you.
Thank you, Patricia. Currently, the policy says that applications must be submitted via the branch offices manually. We do not have a digital system where applications can be submitted. So we do not accept emailed applications. Thank you. Thank you.
Selawani, I think the next question is also to you, Selawani, from Kane. He's asking for an intended import tariff determination. Must this application be submitted at the branch office where the intended product will be imported? And can you submit a sample, and will these be returned to you after that determination?
Thanks, Patricia. The applications for intended imports are submitted directly at the head office because there has not been a bill of entry. They can submit a sample. It will make it easier for us to provide a determination quicker. And yes, we do use pro forma invoices as well. So intended importations directly to the head office. Thank you.
Thank you so much for that response. The next question is from Violet, and Letitia, if you can handle that one for me. It's how regularly do SARS update the tariff system?
Thank you for that question, Patricia. If the question is the tariff system, every time there is an amendment, which is also published on the SARS website, the system is updated and the new book that is generated is also placed on the website. Thank you.
Thank you so much for that response, Letitia. The next question is, Selewani, will SARS have a section in e-filing under the customs section to submit a tariff determination? They're saying that this functionality will then allow for uploading of documents required for the tariff determination. So the question is, will we have a section under e-filing to submit a tariff determination?
Thanks, Patricia. Unfortunately, currently, applications for tariff determinations are still done through a manual process, but there are plans internally to upgrade the system and integrate it to the digitalized and other customs systems so that in future, our clients can be able to apply through e-filing. So to be brief, no, the e-filing does not have provision for application for tariff determinations. I hope that clarifies it.
Yes, thank you very much for that comprehensive response. Hermie, if I can give you the next question. Can a TDN application be done at notice of intent stage when a decision is being done, meaning a letter of demand? And that question's from Lerato.
Absolutely, Letitia. An application for a tariff determination can be done at any stage. It can be done before you import your goods. It can be done when your goods are stopped and you, for instance, receive the letter of intent, or at the stage of letter of demand.
Thank you so much, Hermie. The next question is from Wanda, and she's asking if there's a cost involved from SARS when applying for a tariff determination. Selewani?
No, the application for tariff determination is free of charge. And that's how well we want our traders to comply. So we do not charge, so it's for free. Thank you.
Thank you so much. The next question is from Eugene, and he's saying, when will SARS start to publish tariff determinations, and will that be retrospective? Section 4 is prohibitive in that regard, but can tariff determinations not be published? I think redacted, he's indicating. Selewani, back to you.
Thanks, Patricia. We are currently working on processes, as you have mentioned earlier, the legislation, the system itself, to ensure that the determinations that we issue are published so that it will be easier for our traders. The retrospective effect, I'm not sure about it. I think it will depend on when the commissioner issues out the communication that now we are able to publish. Maybe we can find out from our legal colleagues, and then we will email the trader back with a final answer on the retrospective part of the question. Thank you.
Thank you so much. There's a very long question. I think we will respond to that one in our question and answer session, which will be available later from Thokozani, because he goes into a lot of detail about processing warehouse entries and warehouse entries. So I think we'll answer that one in detail at a later stage, if that's okay. The next question is from Kane. Hermie, if you can get this one. He says, if an officer makes a decision, is this verified by a senior officer before sending to the trader? And can you request a reason for the tariff they decided on? How do one do this? Can you question the tariff decision before having to lodge a tariff determination application, taking into consideration the timelines, and not just for an officer to stick with his decision and make it the burden of the trader to prove classification? I'm not sure if you got that question, if I should repeat, Hermie.
Patricia, it's quite a long question. The first part I see more applicable to the legal side to answer, and I think the second leg could go to another colleague. Sure. But I understood the first one. So first of all, yes, before an officer actually make a decision, there are quite a few other officers involved in that, including a senior officer or a manager. We actually follow the Public Administrative Justice Act, in short PAJA, where we would send a trader a letter of intent or a letter of findings, where we would say that, look, we think the goods should be classified under a certain code. And so we would give you reasons for our findings in there, and we would give you an opportunity actually to give representation, to say why you think that it should not be classified in that code. At that stage, also the trader can actually apply formally for a tariff determination at head office. That's Silwane and Lydia's section. Where they could also come and give a finding. If the finding is the same as the officers in the front office, and then they would go ahead actually and give you a letter of demand, and that would be a calculation based on if the duty is higher than what you have declared, and then that difference would be in the letter of demand and other possible penalties. But the short question is, yes, it's not just one officer that will make that decision. That decision goes through to other senior officials. Thank you.
Thanks so much, Hermie. I think you have answered the second part of the question as well indirectly, because they were asking if they can query the tariff determination before applying for a formal tariff determination. Answered that question. Thank you. Just looking for the next question. Okay, we've done the turnaround times. We've answered those. The next question from Kanye. Where in the tariff book can one view the WTO bounded rates? Silwane, if you can respond to that one.
So during the presentation, if you remember, there was a slide that Lydia showed that showed the schedule to the Customs and Excise Act that showed the codes, the description, as well as the agreements. Within that slide, there are tariff rates that apply. The tariff rates that are shown there are actually the bound rates that can be paid through a process of importation. I think Letitia can elaborate further on this one, if I may ask.
Thank you, Letitia.
Thank you, Patricia and Silwane. Yes, actually the bound rates is something that is administered by DTIC, and they also appear on the WTO website. So the general rate of duty, that is the first column in the tariff book. That is normally the rate that is applied within the boundaries of the bound rates. But the bound rates is in terms of the GATT agreement, or the WTO agreement as it's now known, and that is administered through DTIC. Hope that answered the question, Patricia.
Yes, thank you so much, Silawani and Letitia. Lydia, if you can take the next question from Marcus. He's asking, is there an expiry on a tariff determination?
Thank you, Patricia. Thanks, Marcus, for the question. A tariff determination remains valid until it is amended by the commissioner. The reasons for amendment can emanate from the trader challenging the decision that was made, and he succeed in his challenge, where within the dispute resolution processes, then SARS decide in his favor. Another option will be if the law is changed, then a tariff determination will be amended in line with the new law. Thank you.
Thank you so much, Lydia. Lufona, I think if you can get the next question for us. Tele is asking, if the customs officer has made a mistake in a tariff determination ruling with intent of imposing penalty, and later the officer agrees to the initial tariff heading after the appeal, will the customs officer be liable for storage charges with the carrier, since it was the customs officer's mistake that resulted in the delay and massive storage charges that have incurred?
Okay, thank you, Patricia, and thank you for the question. Once we reach the stage where the determination has to be amended in favor of the applicant or the taxpayer, the state warehouse storage is guided by, I think, Section 17. There is a provision there which allows the commissioner to remit that storage, but it is very, very complex. But that provision specify, it guides the commissioner. We apply it, and then in most instances you might find that is remitted in full or partly, depending on the circumstances of the merit. You know that each case is determined, is treated on its own merit, but there is provision for that, for the commissioner to remit the state warehouse. Thank you.
Thank you so much, Lufona. The next question from Hermine. Lydia, if you can get this one. She asks, if Rule 3C makes provisions for combination sets, how is this rule applied if each item must be separately cleared?
Thank you, Patricia. Rule 3C, we apply it when we are unable to determine the essential character in terms of rule GRIB, or we did not succeed in applying rule GRI3A. Then in most cases, you will find that the product as presented are different items. So we determine the tariff heading or tariff code of each item, and the heading that occurs last in numerical order then will be the heading for a whole.
Thank you so much.
If they are not presented, as I said, then each product will have its own tariff heading. An example of where we will find different goods presented together, for example, first aid kits. We'll find the kit is comprising of a scissor, bandage, and they are separate goods. We cannot say which item gives the whole in a case its essential character. Therefore, we will determine the heading of each item, and the one that occurs last in numerical order will be the heading for the whole. Thank you.
Thank you so much, Lydia. The next question, Hermie, if you can answer, comes from Marcus. Do the customs officers at branch levels utilize general rules of interpretation when deciding on tariff headings on a letter of findings or intent, as this is not elaborated on the letter of intent?
The customs officials will definitely in the letter of findings inform the trader that we find that the product should be classified under this code for the following reason. So I'm not always sure. Obviously, they would go and consult the HS, but the trader would definitely know exactly what the findings were based on, and they would also ask to respond thereto, or to prove the contrary, or to say why they think it should be classified somewhere else. So yes, they do use the HS, they do use the rules. They would use all material that is applicable to that product, and then also will respond to the representation made. What we find a lot of times is that the traders keep quiet at that stage, and that is a stage where you should come in as a trader and say, I disagree, or I don't understand this, because this is how I see it. And sometimes at the letter of finding stage, there could be like some sort of agreement or some sort of understanding of the trader where they go wrong. But the problem that is faced is that the trader keeps quiet and then wait until a letter of demand is issued. And at that stage, a decision is made, because a letter of finding is not a decision. It is a PAJA process to inform you that the commissioner has a potential problem, gives you the reasons for the intention of making a decision, and that is to demand or to see something that is maybe detained. So that is the stage that we would like the trader to engage with the commissioner on how they find that the goods should be classified.
Thank you so much for the comprehensive response, Hermie. Our next question, maybe Lydia can respond to, is, are the old BTN rulings prior to the HS code still valid?
Can you repeat the question, Patricia?
Yes, sure. Robbie's asking if the old BTN rulings prior to the HS code, are these still valid?
They are valid to the extent that the ruling is on the tariff code that is still applicable. Remember the HS 2022, in some instances, there are tariff headings that are deleted. Some headings are changed. So we use the BTI rulings or the publications to the extent that they are in conformity with the legislation that we are administering. Thank you.
Thank you so much, Lydia. And I think for our last question from Kane, Silawani, if you can respond. If a determination previously issued is changed by SARS, are you informed of the change by SARS with the reasons for the change of the previous ruling? And will a new TDN be issued to you?
Thanks, Letitia, for the question. First, the amendment to a tariff determination depends on the number of scenarios. It could be changed through an appeals process where the appeals committee rules in favor of the client, and we are directed to amend that ruling. The client will be informed, and the tariff determination will be amended with a new ruling. Secondly, it could be that, as in terms of the law or the act, the commissioner picks up that a determination was erroneously issued, maybe to some information that might have come forth, or for any other reason that the client might not know of. So in this process, there is a partial process that we afford clients where we write to them and notice them that there is going to be a change in tariff with reasons as to why that change is going to take place. We will give them an opportunity to respond to the letter, whether they agree or disagree. If they agree, we will change the determination. If they disagree, they'll give us reasons as to why, and then the process will proceed. And the determination is amended with the new ruling as a result. Thank you, Patricia. I hope I clarified the.
Yes, thank you very much for the comprehensive response. I think that brings us to the end of our question and answer session. We will still respond to the questions that we do receive, and there will be a frequently asked questions page that will be accessible for you to view the questions and answers. I think I'll hand over to Bomani for closing remarks. Thank you very much, everybody, for the answers and questions. Thank you. Bomani.
Thank you very much, colleagues, and thank you to the trade community for participating. And continue sending the questions with your emails and specific issues so that we can get back to you and clarify the rest of the matters. On that note, I appreciate everybody and thanks back to you, Program Director.
Thank you so much, colleagues. And I must say that was quite an intense session. Never in my life have I seen so many questions come through from our clients and from our stakeholders. It is really, really, really appreciated. Thank you so much. And this is how webinars are supposed to run, where it's not just an issue of presenting and giving information, but it's an interactive session. And I must say that although we've come to the end of this webinar, ladies and gentlemen, the email address that was presented to you, which is query@TDNs or TDN queries at sars.gov.za, that you can still use to forward your questions to the TDN team so that even after the webinar, you can still get the feedback that you deserve. And after that, please, guys, I would keep highlighting the issue of the survey that we have at the end of the session. Please do not leave without filling in the survey. The system, as we said, once you log off, it will prompt you to fill in that survey accordingly. And I must say the energy levels were quite high tonight. I don't know if it's because of the subject matter that we were dealing with, but we are so excited to have these sorts of interactions because, as we all say, at the end of the day, we open up these lines of communications so that there will be less room for issues and fights later on when people are served with letters of intent and so on. So we really appreciate this platform that was raised by our innovative leadership. This, ladies and gentlemen, now brings us to the very end of this webinar, and it is not the end of the interactions that we are going to have. We will definitely be having much more platforms such as this one, carrying on well into the end of this year. Now, from us, the South African Revenue team, thank you so much for joining us. Salani kahle, hambani kahle, goodbye, and totsiens.
Fellow South Africans, I'm addressing you.
All your years of paying tax, you still wonder, why does it matter?
It is true that we are facing a great emergency.
It matters now more than ever. It matters to those who are exposed to harm to keep us away from it. The ones that leave behind all that they love. Your tax matters to them. Those who spend endless hours standing on their feet to care for others. It matters to those who are always at the heart of any crisis and our future generations. It matters to those who put so much love into giving selflessly to each and every family living on the breadline. It matters to all of us. To all taxpayers, pay your fair share. Do it for your nation. Your tax matters.